Hello everybody, I am Yogesh Pai, Assistant Professor of Law at National Law University, Delhi. Welcome to the e-Pathshala course on intellectual property. Today we are going to discuss module 1, that is Introduction to Intellectual Property, a conceptual primer. The outline of this course basically has to deal with basic concepts involving intellectual property, the nature of exclusivity provided, the principles of alienability, and nature of remedies, of course. We are also going to discuss classification of intellectual property rights into separate categories involving patents, copyrights, trademarks, geographical indications, industrial designs, and other sui generis legislations. We are also trying to give an explanation on each of these categories involving intellectual property rights and some of the technical concepts involving the same. We also will discuss the differences between real property or tangible property in the sense of land and chattels and its distinction and the features that distinguish it with intellectual property rights. Finally, we will conclude with the structure of the course as to how the course will proceed in the next few months, and we will discuss the summary. Intellectual property has its basis in property concepts. So property, as you generally understand, can be divided into land, chattels, and other kinds of intangible properties like shares, of course intellectual property also. So when you talk in terms of land and chattels, these are what are called as real property or movable and immovable properties, and intangible in the context of intellectual property is a specific right. Now what is property? Property in real context is a bundle of rights, and we are going to do a bit of explanation on these property concepts. But before that, why do we need property? Can't contract law, tort law, or other kinds of acts that can remedy unfair competition protect or incentivize creativity or inventions? The difference between property and all these other categories of legal mechanisms has primarily to deal with the nature of remedies. The nature of remedies provided in a property right is in rem, vis-a-vis the nature of remedies provided in other categories is in personam, in the sense that if you have a property right, it applies against the world, but if you have one of these contractual rights or an action under tort law, it may be vis-a-vis a person. So specifically property rights provides you a broad ambit and scope to deal with various kinds of activities involving protection of invention and creativity against the whole world in general. So property as a bundle of rights primarily has two components. It is the right to exclude and the right to alienate. Now if you understand right to exclusion, it basically has to deal with your right to exclude others or third parties from making, using, selling, reproducing, importing, offering for sale, distribution, and concept of right to alienate includes the specific rights relating to sale, distribution, and transfer, right. So both these, exclusion and alienation, are the two core components of rights involving property. The core of property also involves remedy or remedial actions. They are in the form of injunctions, damages, or accounts for profit, and these may be both retrospective or prospective and sometimes exemplary. So why property based protection is important for creating incentives? Is there an argument for economic efficiency when you compare it with other forms of mechanisms? And when we say other forms of mechanisms, they primarily involve subsidies, prize funds or basically prizes, tax breaks, or publicly funded research and development that is carried on by the state. How are these mechanisms different from intellectual property protection or a property based protection? Now primarily property rights are important, or the role of property rights becomes central to governing innovation and creativity due to its perceived economic efficiency vis-a-vis all these other alternative systems that incentivize or that may incentivize creativity and innovation. This can be classically explained through concepts like property versus liability. In a property system, the entitlement that the IP owner or the intellectual property holder has to receive is determined by the market, because market forces will actually decide how much of remuneration should go back to the IP holder once the product is put by the IP holder in the market, and given that it is protected by law. But in case of liability rules, the entitlement that the inventor or creator should receive is decided by some third party. So in all these alternative systems like price fund subsidies, publicly funded R&D, how much it takes to incentivize or how much it takes to foster creativity is decided either ex ante or ex post by some external agency, which may not be in a proper position to decide on the value of entitlement. So ultimately, because the value of entitlement is not decided by the market forces, these other alternative systems may be deemed less efficient when compared to property rights system. Having said that, what is intellectual property? Intellectual property is of a recent coinage. In fact, the predecessor of the World Intellectual Property Organization in around 1960s coined this term to include broad categories of industrial property and copyright. Traditionally, intellectual property as a system has developed through these two systems, industrial property and copyright. Industrial property included patents, trademarks, industrial designs, geographical indications, etc. And copyright involved or was based on authorship, and it also included certain kind of entrepreneurial works like sound recording, broadcast, which are also called as neighboring rights. So why are these two systems distinct? This has its roots in a bit of history. History tells us that copyright was more concerned with authorial creativity, and it has some connection to being expression of your personality. So it was considered distinct from trade and commerce, while other forms of creativity is expressed through technical inventions or through industrial designs, and in certain cases the requirement that your mark be protected or your geographical indication be protected was in relation to trade or commerce. That is why it was classically called as industrial property. We also have certain sui generis legislations. These are the kind of laws which are specifically enacted so that the existing traditional categories like patents, copyrights, trademarks, industrial designs do not actually provide sufficient basis for protection, and that is why certain of these aspects of creativity are to be protected by a different indigenous kind of law, which means it is a sui generis legislation. So these are protection of layout designs, what are also called as semiconductor chip designs, and also plant variety protection. There are other kinds of laws that provide IP type of protection, but there is larger dispute whether these amount to intellectual property rights in themselves. Nevertheless, we for broad purposes include them within the category of intellectual property. They are the common law action of passing off and unfair competition, certain kinds of protection that are needed for protecting trade secret and confidential information. We also provide data exclusivity for test and other regulatory data that is usually submitted to the governments. Some countries also provide protection for non-original databases, and we will discuss along with this a bit of personality rights, and we will discuss these in the next slides. What are patents? Patents protect technical features of an invention. So any form of creativity that involves a technical character and some kind of a technical effect would usually be governed by laws of patents, because patents then protect technical embodiments of inventions. Similarly, what are copyrights? They basically have to do with authors' work. Authors, they can come up with writings as their expression, music, film, other forms of artistic creativity involving photography. So these are all kind of works that would be usually protected. Introduces or sells the product in the market as if the product is coming from a different source, while not identifying himself with the product, this kind of action and remedy against such kind of violation is a remedy involving passing off. Now, unfair competition may also be used as principles for preventing fraudulent, deceptive or dishonest trade practices prohibited by a statute, regulation and common law. So, what is the underlying philosophy or the concept involving intellectual property protection? So, basically you want to protect certain forms of innovation and creativity, either to provide incentives against market failure, because the more and more one comes up with invention, and if they are allowed to be free rided, then the person will not have an incentive to produce further. So, there is market failure in innovation and creativity. And there are other kinds of issues that you want to resolve in the market, basically that relate to information asymmetry, wherein you want to protect the consumers against deceptive practices, because people may use marks that do not belong to them and may create confusion in the market, and that can be harmful for consumers. So, there are both kinds of aspects that involve the underlying philosophy. One is to prevent market failure in innovation and creativity, and second to resolve information asymmetries. But common to both these is the principle of differentiation. Intellectual property protection primarily has to deal with how differentiated goods and services, by virtue of innovation, creativity, or by virtue of creation of a goodwill in the market through projection of their marks, how can these products be differentiated, and how can law provide protection to differentiate it in actual markets. Now, what is the difference between real property and intellectual property? In our previous discussion, we saw that the primary concepts involving property right, that is exclusion and alienability, has its roots in the property based system as in real property, and that is why most of the concepts that you encounter in intellectual property have to deal with real property. However, there are many distinguishing features involving both property rights and intellectual property, and I would relate some of them here. Unlike in case of land or in case of products as in chattels, intellectual property is easily replicable, in the sense that the marginal cost of producing one additional product involving intellectual property is much easier when compared to physical forms of property or real property as in land and chattels. It is easily replicable, and this is classically because of what is called as the public good character. We will discuss more of these public good characteristics in our class on economics to intellectual property, but suffice it to mention here that public good has two important characteristics of non-rivalry and non-excludability. Unlike in case of land and chattels, consumption of knowledge by so many people at one point of time does not diminish the possibility of each other to consume the same piece of knowledge. Similarly, information once out without any adequate protection, it remains with the person who has got it. So, once the information is given, it cannot be dispossessed from that person. So, it is non-excludable and non-rival in character, and it has important implications of how we understand the economic differences between property and intellectual property. Second, intellectual property can be generally classified as negative rights when compared to the real property which are usually determined as positive rights. So, in intellectual property, it is not so much about the use of those rights positively, but it has to do with excluding third parties from using, making, selling, or any of the specific rights that are granted to you. Now, what are the real implications of having it mentioned as a negative right? So, if you have an intellectual property right, either patent or a copyright or a design, you cannot claim that by virtue of this you have a right to market the product. The marketing and the actual regulations that pertain to safety or other characteristics will be decided by an external law. Intellectual property only allows you to exclude others from actually copying the invention or copying aspects of your creativity. So they are negative in that sense, so that you do not make any kind of positive claims towards marketing or towards positive use of the product. That right is not provided by intellectual property law. Third is the term limitation. In most categories of IPR, patents, copyrights, industrial designs, they are limited by time duration. The reason is because society wants to create a balance between some kind of a monopoly type of protection or an exclusivity protection that is offered to intellectual property right holders vis-a-vis the societal need that the invention should be part of the public domain and more people should be able to access it. That is why the term duration for patents is limited to 20 years. For copyright in India it is life plus 60 years, and for industrial designs it may vary from country to country from 10 to 15 or 20 years. So it is specific in time. However, certain other forms of intellectual property like trademarks and geographical indications can be renewed in perpetuity. It means once you file a trademark application, you will be given a certain specific period of time for protection, and after that, until you are in business and you want to continue with the business, you can keep on renewing the marks, both in case of geographical indications and trademarks. The reason why both these forms of protection allow you renewing in perpetuity is because if you would keep it bound by time duration, and if it falls in the public domain, naturally many people would use that mark, usurp that goodwill and create confusion in the market and can ultimately hurt consumers. So to prevent consumers from being deceived, the time duration that is provided in trademarks and geographical indications is unlimited in terms of protection. Trade secret protection can also be unlimited or in perpetuity, for the reason that by virtue of secrecy you can protect it as long as you have made sufficient or taken reasonable measures to protect it for that period of time. So until you yourself lose the secrecy or someone else misappropriates it, you still have the right in keeping that kind of confidential information in perpetuity. The acquisition of intellectual property is specifically created by the statute. So there are acquisition procedures involving trademarks, geographical indications, patents, industrial designs, and all other forms of intellectual property except copyright, where registration may not be required. The reason is copyright has this principle of automatic protection, which means registration only becomes voluntary and not mandatory. Similarly, trade secret protection, if it is provided through common law or even if provided through certain statute, may not require specific registration. Intellectual property distinguishes itself from other forms of property in terms of its public notice function, and this public notice function is important for third parties. For example, in case of land, by virtue of a boundary or a compound wall, the landholder is able to sufficiently give public notice to the society of what the actual boundaries of the land are. Or in terms of a physical chattel, a good like a pen, a pencil, you actually know that these are the confines of the product. But in case of intellectual property, since the underlying protection is for information and knowledge, how it can become difficult to actually create boundaries. For example, in case of patents, claims define the actual boundaries. Patent claims define the actual boundaries of the patent, and since patent claims are drafted in languages that are known to all of us, and the interpretation of languages can be distinct, the boundaries of the patent are usually fuzzy. So these fuzzy boundaries are because of different understanding of what the domain of knowledge that should be protected. Inventors may have a certain conception of what the claims of the patent are or what the boundaries of the patent are. Once the application is made to the patent office may have certain conceptualization of what the claims are, and furthermore third parties, external third parties will have a certain version of what the claims are or how the claims must be interpreted. Finally, when litigation ensues in the court will apply certain doctrines involving claim construction or patent claim construction, and they will come to a certain conclusion of what the boundaries of the patent are. So ultimately, from the conceptualization by the inventor till the conflict is specifically resolved by the court, the boundaries remain fuzzy, and this is very unique to patent law, unlike in case of landed property, where there might not be much of an argument over whether the landed boundary specifically allows the public a kind of a notice regarding the exact boundaries. There can also be certain specific conditions on the grant of intellectual property. So even before you grant intellectual property rights, they may be subjected to conditions which you cannot refuse post grant. For example, intellectual property rights in the case of patents are subject to research exemption, or also called they may also be subjected to Bolar exceptions, or also called as regulatory review exceptions. Copyright may be subjected to fair use, and also in case of trademarks, marks can be subjected to honest and concurrent use. Courts also determine the boundaries of intellectual property. So even if a property right is validly granted, for example a patent has been granted, it does not ultimately mean that the particular boundary of the patent is clear. It can be negotiated and renegotiated in litigation, and sometimes external laws like competition law can actually determine to some extent the type of use or whether it amounts to abuse of monopoly. So in some sense there can be laws that require you to limit your monopoly. So that is very unique to intellectual property law, in the sense that application of external laws can also influence the amount of monopoly or market power that you can hold. Similarly, court can also tailor the boundaries of IP in the sense that, for example, since copyright does not require registration and that registration is voluntary in copyright, the question of the threshold requirement of originality, which is required for all kinds of works involving copyright, will ultimately be decided in a litigation by a court of law. So until then, copyright requires very basic minimum level of creativity, which is called as the criteria of originality, which only when challenged in the court of law can be conclusively determined. So courts can often actually tailor the requirements of monopoly and also tailor the boundaries of intellectual property. Injunction and other remedies are provided as much as in case of any property right, and preliminary injunctions may not be sometimes easily granted in case of patents, because in case of patents, determining ex ante the claims and the technical arguments involved may lead to an extensive trial, and if that has to be avoided, then the courts must actually look into principles of injunction, which is usually called as the 4-factor test, and try and decide whether in certain cases a remedy in the form of an injunction should be given or not. However, in case of trademarks, a remedy in the form of an preliminary injunction may be easily handed out, because there are certain effects that relates to consumer deception. Finally, in case of property rights, restitution is usually allowed. Restitution means that the defendant shall be put in a position of which he actually had at the time when the wrongful action began. But in case of intellectual property, suppose a patent is granted and it is granted by the patent office, and after several years if it is challenged in the court of law and the court of law declares it as an invalid patent, the consumers who lost by giving a price which is in some sense a monopolistic price will be the losers, in the sense that they will never recover the price that they have paid to the patent holder. This is only in cases where the patent is subsequently, or any other IP right is subsequently declared as invalid. For that period of time where there was a presumption of validity and where consumers have already paid for the product, they shall not be restituted. Finally, I will explain to you the structure of this course. The basic foundations involving this whole course are provided in module 1 to 8, which would require a study of historical aspects as to the universal origins of intellectual property law. We will discuss a bit of how intellectual property evolved in Europe, in America, and a bit of it about the Indian law and how, in the earlier British era they were enacted, and subsequently post independence what has been the reforms involving intellectual property. So, from a historical perspective, and some important lessons also to learn from history of intellectual property. Second, we will also learn the theoretical paradigms involving intellectual property, or the theoretical aspects. Here we will try and look into various theories propounded by property theorists like Locke, Hegel, Kant and others, and how they can be used today to justify intellectual property, of course with certain limitations. We will also look into economic aspects as to what is this market failure in inventions, why intellectual property is a system that is often talked about as creating some kind of an efficiency, also some kind of a dynamic efficiency, because it provides incentives to innovation, although the price that the society has to pay is the loss of price competition. We will also study some international law aspects involving treaties like the WTO TRIPS agreement, that is the World Trade Organization's agreement on trade related aspects of intellectual property rights, which is enforced since 1995. Also along with it, we will also study important WIPO treaties like the Berne, Paris and other conventions that are referenced in the TRIPS agreement. The reason why we have to study the international law aspects is because by virtue of the creation of the WTO, including the dispute settlement, these treaties are enforceable in international law like many other treaties, but which has special ramifications in terms of domestic compliance. So, for example, Indian laws have to be compliant with TRIPS post India signing the WTO agreements. We will also study certain aspects of the convergence between competition law and intellectual property rights, or the conflicts involving intellectual property rights and the competition law and policy. This is very important because most jurisdictions are not able to settle whether the relationship has certain tensions and how those tensions should be resolved through legal mechanisms. Because competition law has to deal with dynamic efficiency to promote innovation, and intellectual property serves the same purpose by providing market exclusivity. Most scholars on this point have raised an important issue that both the ends are the same. However, there may be tension in the means, because intellectual property provides market exclusivity while competition law seeks to somehow deter any kind of market exclusivity or monopoly unless it is specifically provided through law. Finally, access, human rights and constitutional dimensions of intellectual property have to be understood. So, in this module we are going to understand the public policy aspects involving the effects of intellectual property rights, primarily because intellectual property rights allows through its market exclusivity to raise prices, and how price based competition might be stifled due to certain kind of use and abuse of intellectual property. How free speech, human right to health and other constitutional dimensions of access, how can they be resolved, will be discussed in this specific module. Furthermore, module 8 to 41 will discuss the core of intellectual property rights, both in terms of its substantive and procedural content. In these modules, you will discuss the subject matter threshold distinctly involving patents, copyrights, trademarks, geographical indications, industrial designs and all other forms of intellectual property rights, and what kind of subject matter they protect and why they are different. We will also discuss the qualification thresholds. So, patents, if certain subject matter is protected, what are the qualification requirements that may warrant such protection? in the form of novelty, inventive step, utility or industrial application. Similarly, originality in case of copyright, distinctiveness in case of trademarks. So, we will study these qualification thresholds. We will also study how copyright law defines inventors, authors and the creator and its relationship with property. Then we will also discuss the scope of rights and how those rights get exhausted after the first sale, whether the rights get exhausted nationally or territorially or internationally, because it has important ramifications in terms of availability of competing goods in the market, although intellectual property protected. We will also discuss ownership aspects and assignments aspects or licensing aspects of intellectual property rights, because as I mentioned, one of the core rights that are granted to intellectual property owners or property owners generally is a right to alienate your property. So, how ownership is then used in terms of assignment and licensing must be studied under this module. So, we will also discuss limitations and exceptions, which usually goes without compensation, in the sense that such limitations and exceptions are provided because of certain limited nature, since they do not usually conflict with the normal exploitation of the patent or normal exploitation of the intellectual property rights, and also provided they do not unreasonably prejudice their rights while considering the third party interests. So, what are these various limitations and exceptions granted in patent law, like research exemption or regulatory review exemption, or in copyright law in the form of fair dealing or fair use, statutory copyright exemptions or statutory licenses. So, we will study each of these in detail. Use without authorization and government use can also be regarded as an exemption. However, these type of exemption can involve specific payment of remuneration, and there may be additional conditions attached in the way such authorization is granted and such authorization is used. Finally, we will discuss a bunch of modules involving remedies and enforcement, both civil and criminal, because in case of copyright and trademark law it involves additional criminal remedies. However, generally most intellectual property laws at the core, they have the injunction, accounts for profits and damages as part of civil law remedies. So, this is how we are going to evolve this course and discuss this course modules in the days to come.